to London DevOps meetup number 76. Remember that number, it'll be important later. Thank you all for coming. I can see some names from places as far flung as Peterborough, Cambridge and Norwich. So we're really kind of spreading out our London user base to a further afield. Mentions of Edinburgh as well. So, and I'm sure we've got people internationally as well. Obviously our speakers are speaking from internationally. We've got Patrick on. Thank you so much for coming again, Patrick, from Ghent, I assume. So yeah, welcome to London DevOps 76, the second in our summer sessions, all of which have ended up being themed around generative AI, which I think says a lot about where the industry is going at the moment. So yeah, this is the second of 3 summer sessions. So previously we had John Willis speaking. We put the video up of that. That went up yesterday. So if you haven't seen that, yeah, an hour on John Willis and Patrick Dubois riffing on generative AI is absolutely awesome, blew my mind. And I'm sure we're going to have our minds blown again tonight. So yes, thank you everyone for coming. What is London DevOps? Well, here's what DevOps might be to you or to me, lots of tools. To a lot of people, DevOps is building culture. I think it's quite a lot of these things and much more. This is my favorite definition of DevOps, a culture where people, regardless of title or background, work together to imagine, develop, deploy, and operate a system. Thank you to Ken McGragy from ThoughtWorks for that one. London DevOps specifically, we've been going since 2014, and we, just for anybody who's new here, hasn't been to a meetup before, we generally meet about once a month in the London area. Over the summer, things get a bit quiet, so we don't generally physically meet up. Everyone's off on holiday or sunning themselves or down the pub. Note to Americans, that's what we call a bar. And so we go virtual, but yeah, generically, we are meeting about once a month. If you've got a venue we can have in the London area, then please let us know. If you can fit about 100 people in, that would be awesome. About once a month we meet. We meet to share the knowledge. We meet so that everyone can meet new people, help each other out. And much like the talks tonight, everything you hear is shareable, unless you hear otherwise. All of our meetups, unless we have a technical problem, go up on YouTube. So here's our YouTube channel. Just type London DevOps into YouTube and you'll find us, or go straight to that link. And yes, we're recording tonight. And so in a few days' time, assuming nothing goes wrong with recording, we'll put this session up as well. So that's all that there for you. There's our code of conduct. Yes, this is more important than a physical meetup, but it still applies on Zoom. The code of conduct, I always make a terrible joke when I'm talking about the code of conduct, but I'm stopping doing that now. I'm just going to put the code of conduct up there. There it is. Please read it. Please take notice of it. And hopefully we won't have to have a third occurrence of enforcing the code of conduct. I doubt it. That's 3 occurrences over like 9 years. So I'm not too disheartened by that. And I did say I wasn't going to make a joke out of it, so I'll stop talking right now. Okay, so yeah, this motley crew's been together since 2014, organising the meetups. And yeah, it's very much a team effort. I mean, I'm the guy who stands up and tells terrible jokes most of the time at the front, but it's absolute team effort in getting these meetups going, both the virtual ones and the physicals. I think we're all here tonight. So does everyone, well, one at a time, do you want to introduce yourselves? Mark, do you want to say hello?
Yeah, hello everyone. So welcome to London DevOps and thank you for coming.
Awesome, awesome. Skip over the guy in the purple shirt. Jack, you're here, aren't you? Do you want to say hello?
Yeah. Hi everyone. Again, thanks for coming tonight. I hope you enjoy the speakers, and big thank you to our speakers both. So yeah.
Wonderful. And Alex, there's at least 2 Alex Dovers on the list, so I just was one of them wants to come off mute. Say hello.
Hello, hi everyone. Good evening or good morning, whatever time it is where you are, and thanks for joining London DevOps. Good to see you.
Thank you very much, Alex Dover, number 1. You're always number 1 to me, Alex Dover. So yeah, we're your organisers. If you're on the call and you're interested in speaking, if you're interested in offering us a venue or sponsoring, even, doesn't take a huge amount of money to run these, but it does take a bit, then please do get in touch with any one of us. Similarly, if there's anything that you think we can improve, anything you don't like, then please do get in touch with one of us. Those @ signs are referring to some social network, which I think is now called X. So you can contact us on that thing if you particularly want to, or not. So yes, sponsors, I just start talking about sponsors, and it's an opportunity for them to just say hello briefly. Firstly, again, since 2014, we've been sponsored by Prism Digital, and that's Alex Dover. So do you want to say a few words about Alex? A few words about Prism?
Yeah, no, thanks, Matt. So we're a DevOps and cloud talent partner, stroke recruitment business. So if you're looking to hire DevOps engineers, give me a shout. If you're looking for a new role in this industry sector, give me a shout. Or if you just want to talk about the market trends, salary benchmarking, technology trends that we're seeing our clients use, very happy to have a shout and chat about that as well. So that's me, Prism Digital. Thank you very much.
Thank you, Prism Digital. Second sponsor, again, not since 2014 because they've not been around that long, but doing some brilliant work and growing very, very fast in a very short period of time. Amazing work from Chris and Jack. Do you want to say hello, Jack?
Yeah, thanks, Matt. Hi, everyone, again. So we're a DevOps and cloud technology consultancy. So we work with, sorry about the background noise of children arguing over yogurt, by the way. But so we work with from kind of technical and business advisory. So hello, and enjoy the show.
Brilliant, thank you, Jack. And if you're offering, I'll have an apricot yogurt, please.
It's all going off here. It's all going off here.
We can't really hear very much of them, so it's fine, Jack. No problem at all. Next sponsor we have is O'Reilly. So O'Reilly, I'm sure everyone knows O'Reilly, publishers, velocity originators, etc. They also send me a massive box of books to give away once a year or so, and tonight is no exception. So tonight we're going to have a quiz a bit later on, so pay attention during the talks because the questions, admittedly not particularly difficult ones, are going to relate to the talk that we hear tonight. Whoops, oh god, it's all going Pete Tom, there we go. So yes, so O'Reilly sent us 3 books. I'm going to show you the books. If you win the quiz, which we'll do at the end, and you're in the UK, because I'm not posting out heavy books outside of the UK, sorry, they didn't pay me for that, then you can win one of these 3 books. Here's the first one. It is reflecting badly with my ring light. Security as Code. DevSecOps Patterns with AWS. There's that book you could choose if you're the winner. There's DevOps Tools for that way for Java developers by a number of, I believe, JFrog employees wrote that book, so that's a good one. And the third book is Hacking Kubernetes by Michael Hasenblas and our good friend Andy Martin, who I think a few people on the call know and love. So yeah, that's the quiz later on. Cool. Right. So, and our final sponsor, well, not final sponsor at all, really, our best sponsor, really, because we're using their Zoom for this tonight, is JFrog. And Ari, I'm going to hand over to Ari just to say a few words and ping me when you want the next slide.
Absolutely. Well, hi, everybody. I'm Ari Waller. I'm the Community Meetups Program Manager for JFrog. I'm joined by Julia Bettinelli, who is my partner in all of this. And we're just really excited to be part of your community. You know, not many people these days, especially after that long pandemic, can pull off online meetups. And I'm always like, you guys know how to do it. I don't know how. I sit in so many other ones and sat in hundreds, but London DevOps has this down where people will actually not just want to leave. They want to be here. So it's a great way to spend the summer for online meetups. So it's an honor to be part of your community for that. Like you, I'm looking forward to hearing Mark and Shannon. Just really quick about JFrog. I don't feel like for DevOps meetups, I typically have to do long introductions. JFrog, best known for Artifactory, started back in 2008. However, today we're much more than that. Universal supply chain platform for your DevOps and security needs. You can go to the next slide. One of our core values here at JFrog is community happiness. I was told when I was hired that was my mission, so that continues to this day. We have a raffle for attendees today. JFrog is going to give you a chance to enter Apple AirTags. For a long time, these weren't available. I think they're suddenly back on the market, which is nice. So we're happy to be able to offer those to a winner today. Now, because this is a virtual meetup, I can't do live drawings because of compliance. But anyone that enters, I'm going to go ahead within 2 business days, you're going to be contacted by email. And once you formally accept the prize, we are going to send you your Apple AirTags, and of course, share your name with the London DevOps community to know that somebody actually won these and not me. I bought some at Costco last weekend, so I'm all good. Thank you very much. The next slide, and we'll also drop that link. Also, if some of you, I know that there's a lot of DevOps veterans, even pre-DevOps veterans that are joining us today. However, for those of you who are a little newer and are interested in an introduction to package management course, specifically for the Central European region, on August 17th at 11 a.m., we had a DevOps 101 introduction. So for those of you who are interested in listening to a webinar, I've heard Gotham many times. He does a great job, gives a great overview, and gives you some really great practical things for those of you who want to get down to the basics. Other than that, really excited, and thanks again, Matt, for having us be part of London DevOps this summer. I almost feel like I'm there.
Always a pleasure, Ari. Thank you so much.
Thank you.
Yes, so yeah, JFrog are sponsor the meetup in general. They're also providing the Zoom. Yes, thank you so much for that. Yeah, pre-DevOps veterans. We might have a couple of them on the call actually, but you might be a little bit beyond this one. Mark, Patrick, etc. There we go. So yeah, please do sign up for that. Okay. Next slide. DevOps Days London is happening in September. So yeah, there's still a 20% discount code. There are still some tickets available. So please do go and sign up there. Yeah, I've been to a number of them. It's a great conference. I'll be there this year. I've even got my DevOps Days t-shirt on today. So yeah, it's a bit of an old one, but there we go. Gosh, it's been 10 years event, yeah. So yeah, please do sign up to that if you can. QE2 Centre over in Westminster, great venue as well. So yeah, hopefully see you there. And we're about there. So yeah, we're going to have a talk, a no slides talk, which we've had a few of them in the past. And as an organizer, people come to you and say, we're not going to have any slides. You're like, oh my God, there's going to be no structure to this. It's going to be terrible. And the reverse is almost always true. In fact, it's always been true 100%, thinking back on the no slide talks that we've had. So yeah, so Shannon, Joel, and Mark will be speaking. Sorry, Joel, wasn't sure you were coming or not, so I haven't put your picture up. But there we go, chaos presenting. Yeah, love the sign of that. So yeah, that's it really. There's the last slide. Tell us what you think. There's our email address there. You can contact us on the meetup page as well. So that's the QR code on the right. Also, something we've been trying to build up a little bit more in the last few weeks / months is our LinkedIn presence. We kind of want that to live outside of, we want the meetup group to live outside of meetup.com. Not because there's anything wrong with it, but just because we want more of a continuing presence that's a bit more, a bit closer to where people are spending a lot of time. So yeah, the LinkedIn page is doing better now. We're putting more things on it and trying to remember to do that. So please do go and follow us. Do you follow people on LinkedIn? Yes, I think you do. Yeah. That's that. Thank you. Right. So time for me to shut up now and hand over to our speakers for this evening. Yeah, not quite sure how this is going to work, but I'm cool with that. I'm totally cool with that. So yeah, please do turn up to 11. Go for it, Mark, Shannon, Joel. Floor is yours. Thank you.
We've got it. Thank you so much. Thank you for the invitation, specifically to Mark Cluett. Mark, long time no see. It's been a while since I've been to London, but thanks for the invitation. When Mark first came to me and said, would you like to give some kind of talk to our user group? I said, sure, but I'm going to bring along some friends because what I like to do is have some kind of confrontation on a meeting like this. So Joel and I have had a podcast for the last 9 months called, you're kidding me. That's in my EULA, my end user license agreement. And that has actually morphed into a new show that's going to launch in September that talks about the legal ramifications of using AI and the different platforms. And I thought it'd be great to have him come on to talk a bit, and then to bring in Shannon as not the contrarian view, but just the contrarian in general. So for those of you that don't know Shannon, I like to call her the godmother of DevSecOps because she's the one that taught me about DevSecOps. If you don't know a little bit about me, I did start DevSecOps Days as Patrick started DevOps Days, which is still going strong. Both of those are going. The thing that we want to cover today is there are reasons and things that you should be aware of when you're using AI. And I want to start, Joel. I'm going to just kick it over to you for a little bit because you and I have talked about this quite a bit. I want to get warmed up. Can you kind of give me just the 30-second overview of the Steven Schwartz case and what happened in New York Federal Court?
Sure. Hi, guys. Thanks for having us. Thanks for having me. I'm Joel MacMull. I'm a lawyer in New York and New Jersey. I chair my firm's intellectual property practice as well as its internet law practice. And of course, query what internet law means in 2023. But it's fair to say that it certainly incorporates AI platforms, and I am increasingly finding myself from a legal perspective delving into these issues because as a service provider, I'm pleased to say I've got a good number of clients that are asking questions. It's usually from the employment side, meaning what does their liability look like if they or their employees are using these tools in rendering their own services, whether those services may be accounting services, financial advisory services, even some doctors have asked. My firm happens to represent a lot of doctors and dentists. So this is happening in real time. But with respect to Mark's question, and of course, this resonated with me because the story I'm about to tell is exactly what I do. I am principally a litigator. I do some counseling. I certainly started my career off.
Well, Joel just went off. Is that just me or was that everybody?
Joel's gone off.
I think we lost Joel.
No, can you hear me now?
Oh, there we go. There you go.
Yeah, that was a weird thing. It was like the Zoom just dropped, and
I was just telling you to get to the punchline.
All right, very good. Okay, so as I was saying, here's the story in a nutshell. A lawyer, a plaintiff's personal injury lawyer, decided in his infinite wisdom that he was going to sign a document on behalf of his partner. And his partner had relied on quote unquote authorities that he had received from, I believe it was ChatGPT. The other side gets his papers and they look at those citations. And just quickly, every legal case in the United States, as I think it does also in England, has a specific citation so that you can track it down and read the case. Well, these citations could not be found by the defendant's attorney. They wrote to plaintiff's attorney and says, we can't make sense of, let's say, 10 or so of your citations. They don't seem to exist. What say you? And that began what I think was certainly a very embarrassing affair for the attorneys. So long story short, what ends up happening is the attorney who signed the pleading without reviewing his partner's work ends up lying to the court with respect to the fact that he says he was on vacation when the court was making certain inquiries of him. In fact, his partner was on vacation. He was waiting for his partner to return so that he could essentially have his partner who had authored the document respond to certain inquiries. And so it was lie, built upon lie, built upon lie. Long story short, it emerges rather quickly that the sources that are purportedly legal sources were in fact derived from ChatGPT. They were erroneous. They simply didn't exist. It's not as if there was an error with them. They just wholeheartedly did not exist. And so that in turn prompted a proceeding in which a very senior judge in the Southern District of New York, which is essentially the Manhattan District, conducted a hearing. And he said, confirming all of these lies, essentially what I'm telling you, and then issued an opinion about maybe 2 weeks later, maybe not even, in which he only fined the attorneys, I think it was $5,000.
That pissed me off too, Joel. You and
I know it did.
It's
I know
like,
it did. We talked about it. You thought it was a great injustice financially.
I think it was based upon what he does. Shannon, I want to bring you in on this because when
I
you
was going to say, I don't think it was an injustice. I think that he sent a message. And then I also think that he added some things that I thought was also going to provoke a greater amount of legal problems for those lawyers, which was they had to send out the information they gathered to the judges as part of that verdict. And
Well,
I
his
think that
career
was
is
actually
done.
Part of
Yeah.
the sanction was, as I recall, was the judge's opinion, which was about 20 pages, 20 minutes, had to be included in any resulting engagement they make with new clients. I mean, needless to say, these guys have
Yeah.
been embarrassed. These two guys were so embarrassed and have been embarrassed. More importantly, yes, he only banged them for $5,000, but their career, at least for the short term, has effectively been ruined. I mean,
yeah, I mean, they've lost thousands of dollars thereafter. So it's
hundreds
not
of
like
thousands of
Well, they've
dollars.
lost any
Exactly.
kind of credibility. Screw the money. It's the credibility is gone. Shannon,
totally.
what you and I had discussed on this one when we first started following was the damn AI was just hallucinating. It was making shit up.
Oh yeah, it has that problem. I mean, if you think about it, this lawyer goes over to a prompt, asks a question, gets back some information, doesn't realize he needs to actually like go chase down whether that information is real or not, which is definitely something he should have been doing, but has no idea, right? I mean, there's just literally a, search box. And so it's not like they're getting training, they're not getting like a pre-tutorial, you're not being taught about things like temperature or random noise or hallucinations. And so, this lawyer in my mind has been going after putting information down, but I still think that there's a little bit of, in my mind, responsibility on the part of OpenAI for what they're doing to make it easy to use it.
Right.
No,
And
I don't go for that. I don't buy into that, but
Yeah,
Joel,
okay,
you're
well, I do.
so this case, not surprisingly, has prompted law firms, much like mine, to develop an AI policy. And I did not take the first draft at it, but I also sit on my firm's internal technology committee. And so I looked at it and it's a mess, not surprisingly.
Well, you can get AI to fix that.
Yeah, right. Well, that was the joke. We actually had someone as a goof had AI write our firm's AI policy, like just at least take a stab
oh
at it.
yeah.
Talk about your feedback loop. No, I mean, it's a mess because of course we're trying to set up parameters and guidelines and, there's 1,000 permutations. So I've made some suggestions to it, but,
Well, technology is advancing a lot right now too. I mean, there's so many permutations now, different models. And so I keep seeing people talk about generative AI as if it's ChatGPT, and they kind of are missing the understanding that they need to have. This goes back to what I was saying. I think there's some responsibility on the folks that are generating this stuff for the world, right? That they should have to almost figure out how to train people. What do they, need to do to be able to leverage this set of capabilities well? I'm not saying like you need to make me a PhD at it, but I should know some of the basic things, and it shouldn't just be a prompt if there's a bunch
So
of things
should
I should be
Microsoft
doing.
train people that are just getting started with Word?
They do. They have
No,
a
they
little
don't. They don't
flippy
have to
guy.
do
Oh,
that.
please, they have the little question mark. Where is the, have you clicked on the little question mark for ChatGPT?
No.
Exactly. You know why? Because it's buried off in the right-hand side and no
Patrick
one
says,
talks
do we
about
train
it.
people to use the internet? I think Patrick and I are in agreement on that. We could talk a lot along this vein, but
There is a book on how to use the internet, I will tell you.
there are different legal aspects I want to look at in the next half hour too. Joel, one of the other things that you and I talked about away from that case, and no new subject here, is the Midjourney case, where there was an artist that created content, and this has really played into the mainstream now, is who owns the content once it's generated. Let's not even get talking about the Sarah Silverman way yet. I want to talk about who owns the final content if you're using an engine like this.
Well,
Joel?
that's great, because the laws in the United States, and again, I can't speak to English law or any other jurisdiction for that matter, but the laws in the United States, if you remember, we've talked about this, is that effectively a human has to be the originator of the work. That's the language we use in copyright law. It's called a work. And so it becomes very complicated when you now have, an AI platform generating. This was, as I recall, this was the creation of an anime character, wasn't it, Mark? That's my recollection.
No, they had done like 10 versions of some kind of image that they wanted to create, and then chose one of them. And then once they put that image out and said, this is ours, then all hell broke loose.
Right, but the image, as I recall, was like a cartoon or anime image. But in any event, it doesn't matter. But you see, that's where that's where the real, the rubber meets the road, is in that selection process. Let's say you have an AI generator, you're generating 10 images. If the human at the end of the day is nevertheless the one selecting it and presumably publishing it to the internet, but at least selecting it, is that enough human creativity for purposes of creating an interest in the work that would be, amenable to copyright registration in this country? I've seen arguments go both ways. I don't think it's, at least when I last looked at this a couple of months ago, I don't think we're going to have a definitive statement on this. And I have a sneaking suspicion this issue is going to find its way to the US Supreme Court within the next 2 to 3 years, particularly on the copyright front, which is what is, we have some guidelines now, but people are really going to look to clarify that, because there's a ton of content there that could fall on either side of that dividing line. And I think we really need, I suspect we're going to need some real clarification.
Shannon, what do you got?
Yeah, so here's the thing. So we're talking about the law piece of it, and it's super important and critical. But what rarely happens is law getting translated into technology paradigms. So where do you go to be able to leverage, say, this legal information? Do you go to the EULA and input that into your model? Do you actually go and look and see if it's copyright material? Do you actually leverage maybe robots.txt to be able to inform what you're trying to accomplish with automation associated with it? And I think that's where you're going to see that there's some challenges, is even if you could legally deal with the ramifications, how are we actually translating that into standards that we're all using? Right now, most of the use of AI, LangChain, some of the other kinds of technology that are out there, there essentially isn't anything that's guarding the information being put in as an input or potentially being used in training, outside of maybe, say, some of the actual models out there and actual technology saying we're not going to use your input to train, which now if you look at OpenAI, they talk about if you're using their API, they're not going to supposedly use your information to train. I'm not sure how exactly they're accomplishing that, because they're not real transparent about it. But my concern is about how do you translate the legal to the technology stuff to make it so we're all capable of doing it well. This goes back to my whole notion about are we actually educating people on this? And I know we're talking about the internet as the reason why we shouldn't train people, but I'm going to just tell you, coming back around, this is technology that's very challenging. It's been put together by PhDs. I don't know that we've like lowered the bar significantly to the point where we're actually letting people in and leveraging this information, but they, again, don't know what they need to tune, tweak, how to actually leverage it in a way that gets back the result they're actually looking for.
Well, look, you're not asking a question, but let me just add to that. I mean, there's a huge disconnect between the speed with which technology moves and the speed with which law moves, right? The old adage, the wheels of justice turn slowly. That's true, certainly too, on in the terms of the development of laws, never mind just litigating cases. And I don't, The good news is, and I think I've said this to both of you before, is that in most models, so for example, when trademarks hit the internet, it was a big deal, and everyone, there were certain practitioners that thought about a new paradigm, and did the old trademark laws we have in place apply to the internet? They have. I mean, there may be a few additional wrinkles, but it's not as if we have to, thank God, upend the entire, in the context of trademarks at least, the entire regime to account for advancements in technology. I think AI is a little different for a couple of different reasons, not the least of which is I think there's a democratization of knowledge that comes with the platform, and that creates some unique permutations that don't exist on the trademark front. But I'm kind of hoping that, when we figure it out, and it's certainly still an ongoing process, we're not going to have to essentially be reinventing the wheel.
Here's another topic. Shannon, I see you getting ready to say that, but I want to pull in another topic too as we're doing this. The New York Times last month had a podcast that one of the segments was on Sarah Silverman, if you know her, the comedian. And she is actually suing because the engine can create jokes like hers. So the engine has gone and scraped her content in, and somebody typed in, "Tell me a joke in the voice of Sarah Silverman," or in the style, and it came out, and she said, "That sounds like me." And so she's saying, that's my content. You don't have my approval. And I'm wondering where we are right now in that. What is the approval process where, as an example, Zoom just came out with their brand new EULA that they extended and said, we own everything that you do on Zoom, and we're going to suck it in to train our AI and large language models. Joel, I'll start with you. Oh, no, Shannon, I'll go to you first because I always go to Joel. Where are we now with consent?
If you look at technology consent, there's been advances with things like privacy, being able to do cookies. Who's not pissed off by how we implement cookie consent these days? I'd be surprised to find a few that are like, I love it. I think it's great. How are we actually putting these things into practice, making it so that folks are actually happy with the way these things are going to come together? And the idea here is consent. How do you consent to your images, technology, all of these things being used? I am not seeing a lot of advancement there in terms of the industry. I'm seeing a lot about, content authenticity or content fraud, or being able to deal with the different ways in which you can identify this type of fraudulent data. And I think that's where the challenge is that in technology, the consent area is not there. But if you look at some of the things we've done in the past, like robots.txt and firewalls, and so from a security perspective, what I find is that most of the time security gets bolted on because something didn't actually work with what we were all trying to do. And oh, this protects you, great, we're going to all start to use it, and that becomes sort of the norm. And so, I think Patrick just brought up that there's actually a WAF-like thing for LLMs now. And I think that's where we're going to start to see that if it doesn't get solved with some sort of standard, a way in which we're going to grant consent to content, how we're going to actually deal with licensing models or some of these things, the technology is already out there that's allowing for this, but we haven't really solved with, how are we going to grant that information to people? And that's where I think that we need something almost like robots.txt, if not robots.txt in a next generation form, so that you have to go look it up. Because right now, the fact of the matter is, if you go look at a lot of the sites out there, they allow for indexing, as an example. Is scraping your content indexing, and is scraping your content indexing for the reason to go put it into a model? And that's an interesting area where I just don't know the answer. And I think, I'd go back to Joel. What is the court? What are the courts going to leverage in terms of evidence for your intent on this kind of data? Is sharing copyright notes, what is it going to be that would allow for us to have protections or require licensing? Or, in Sarah Silverman's case, what she's really looking for is, I want to be paid for my content and my style. And so I think that's where, right now, generative AI really hasn't solved the problem of how are they going to monetize actually a basis for having this conversation. I
Joel,
put it back to
before
you, Joel.
Joel, I'm going to jump in real quick to kind of preface what I'd like to hear you take on too, in addition to what Shannon said, is I'm going to argue that scraping has been going on since the internet started. And
Agreed.
easy case is Google. I mean, 1999, they just scraped the internet, right? So I'm wondering is if it's such horrendously bad stuff now, what's being said about Google? What's the legal ramifications of Google scraping the internet every day? Joel?
So a couple of things. Number one is that was litigated, right? You can appreciate that companies has for years across a multitude of sectors have sued Google on grounds that they're basically appropriating their content. The thrust of those cases, as I remember them, and I've not looked at them in a number of years, was it was publicly accessible. Yes, okay, they are aggregating that data. And they're doing things with it that maybe hasn't been done with it before, but it's out there, it's publicly available, you can't whine about it. I mean, that was essentially the
Well, I'm sorry, but I would argue that's what OpenAI is doing. They're not going and scraping private data, they're scraping the net.
Well, let me tell you why it's something else.
I disagree. I think they're scraping both, and there's a
I
reason
do
why
too, but I'm going for the argument.
Well, I don't think they specifically are, but I think their users are.
So this is really interesting because the Sarah Silverman, by the way, Mark, since we spoke about this, not surprisingly, there are a number of musicians that are also filing claims based on the same theory. Write me a song that sounds like Bob Dylan, right? So there's some band actually out there. I'm a big fan of the Pixies. They were, they originated in Boston in the mid 1980s. So someone said, write a song like Frank Black. Frank Black is the pseudonym for the lead singer. And he looked at it. He said, someone put it in front of him and he's like, oh, that sucks. And then not surprisingly, I think it was him, or maybe I'm conflating stories, but bottom line is I know there are suits out there by songwriters under the same premise. And, from a legal perspective, it's not a copyright claim, right? Because no one's claiming, including the plaintiffs, that the content, and nor could they, that the content is theirs. They didn't generate it. So instead, you kind of have it's the redheaded stepchild of intellectual property in the United States called rights of publicity. And this is an area actually that for a brief time, a couple of years ago, I was really interested in, and actually did some talks and wrote a little bit about this because first of all, the law is entirely different in California than it is in New York, particularly as it relates to decedents. But putting that aside, it's really interesting. So what Sarah Silverman's claim is not that the joke is hers, but that, in the way that you teed it up, Mark, that the style of the joke or the song, in the case of the songwriter, is in my style. And what have you done to train your machine to get there? You have essentially violated my rights of publicity, which at least during the course of my life, and I believe this is consistent in the United States, I get to control. I have no idea how this case is going to come out. I did read Sarah Silverman's complaint. I think it's really interesting. I think it's super novel. I think it raises a lot of questions. At the risk of copping out, I think it could also go in two directions if it's fundamentally litigated and not settled. I would suspect, and this is true of 95% of cases that are commenced, that it will settle. Because if it goes to the mat, it could be trouble for either the artist or certainly the platforms. And I sincerely hope the case settles. Because if not, I think it's just going to end up being a loser for both. But
and you're shaking your head yes there on that one.
Yeah, I think this is where if you start to look around about how information can be used, the notion of style is really, really interesting because it actually broaches on the notion of privacy. And that's where you're starting to see convergence on all of these things, right? And this is where I think from a technology perspective, the reason why I'm deeply interested in law and all of this is because as you write software and you're starting to put things in like, hey, maybe I'll put a prompt in here and I'll add a way for a user to do something interesting, unique, and novel. You have that obligation now and potentially liability brewing where you're actually now maybe responsible for the content you're pulling in. And this is where, like, my way of thinking about it is, who's setting their robots.txt appropriately? Has that actually been something that people are thinking about? I can tell you, I've raised that at a lot of companies. And what's interesting about robots.txt is most people are like, oh, it's just for indexing. It's okay. We want to give that stuff. And so they're more lax about their robots.txt. I would actually say I would not be anymore. I would be really deliberate about who I'm allowing to index. And if it's not in that file, I would actually be concerned about that particular file on my site. Because I do think that that's an area where, to Joel's perspective around the right to publicity, I think we all have to get a little bit more intentful about what we're going to put out there, what's behind an authentication gate, because those are things where that's actually providing your intent for potentially legal purpose. And I don't know if it's actually looked at that way. So Joel, I'm going to ping pong it back to you, because my perspective is, as a technologist, we should be using these mechanisms that are out there in an appropriate way. And I'm not sure that they've actually gotten the respect they probably deserve, because before now, they really weren't necessarily something that we would all be super concerned about. But now I actually think this is the place where we should start to think about, how do we actually relay our intent for how our information is being leveraged.
And I want to jump in and go old world on this thing. And I saw the comment from Patrick that said, I want to own my voice, my face, my content. The problem that I'm seeing with all of this is that means that I, as an author, if I admire J.D. Salinger, and I take this to the extreme and say, I want to write in the style of J.D. Salinger. It's almost as if we're saying the potential is there that you can't be like anybody else. Everything you do has to be original. And I'm completely against that I can't use this to actually create stuff in the voice of. That makes no sense to me. And I don't mean the literal voice, in the style.
Right. Well, and look, it's a balancing test, right? Because, let's take the copyright concept of what's called a derivative work or a transformative work. You can write in the style, of course, of J.D. Salinger, and that is not a copyright violation. You can, of course, even build on the themes and the stories that he creates. Your argument would be that you are, I guess the most obvious example, most recent example in the United States was these Prince photographs, these Andy Warhol Prince photographs, where they were basically silkscreened with colors behind them, purple, orange. But the original photograph was taken by, someone far less famous. Andy adds a splash of color and then claims, of course, that it's a transformative work. The Supreme Court recently said, no, it isn't. Because, and it kind of like basically parsed the image. That doesn't answer your question, but I guess what I'm trying to get at is there's a difference between, and look, it may be very, very well be a hairline difference. I'm just merely saying it exists between.
Quit pointing.
that which is yours and that which I can riff on,
Yes.
But that's my argument. Wait, hold on. That's my argument. My argument is that there is such a hairline at this point that you have to be explicit these days about what you're going to allow and not allow. Maybe there needs to be something in your content that says, you can use this for my style. You can use this for extending or derivatives. Like, what is that ability? Because I think this is where, and we've done this, folks, with open source. Who's reading, I know we all love them, the GPL or some of the things considering to decide on what things, what was that? That allows us to bring, I know Joel's reading it, and he reads it for us, right? And I think it's really important, though, to think about the fact of the matter is that our content probably now needs some level of almost like a GPL to it for us to start thinking about how we're going to add this stuff into our technology and extend it. I know you're freaking out on me, but I'm going to tell you, without intent, then you're going to have all of this churn and continual confusion. And if you want to solve the problem of, is this something that I need to go license? Because this is really what it's about. Like, let's be all very honest with each other. It's about money. People are actually trying to say, I made something and I made it so that I can make money off of it. And now you're trying to use it so that you can make money off of it. And the answer is, nothing is free. Basically, if you look at the internet, yeah, there's a whole bunch of things that we can share. But at the same time, it's all somewhat licensed in some way, whether it's an MIT license that says, I don't care what you do with this, or and go make whatever money you want off of it, or it's a GPL that says, here's what you're going to have to do to be able to use my stuff.
You introduced, you're talking about the concept of intent. I mean, the great thing, the great boon to intellectual property, at least with respect to patents, trademarks, and copyright, is that to find liability, intent is not part of that analysis. And so if you're now baking into an intent requirement, you're going to really fundamentally turn on their heads that jurisprudence. Intent does become a factor when you're assessing enhanced damages, or what we call most often punitive damages, because at that point, now we've basically said the law treats them as scoundrels, and the punitive damages, of course, are designed to dissuade either the party or certainly those similarly positioned, the idea being that there'd be some sort of trickle-down notice that's received by them to refrain from such conduct. But importantly, intent is, intellectual property violations in this country are, as a practical matter, strict liability offenses. And we say strict liability because if you do it, you're liable, you're guilty, right? It does not turn on the issue of what your intent was. That's a damages issue and is a little bit.
I'm talking about the intent of the creator. What was the intent of the creator in what they put out there? Were they doing it for publicity? Were they doing it to share? Were they doing it for somebody to build off of? I'm not necessarily saying the intent of the person who's taking the information. I'm talking about the intent of the person who's sharing the information in the first place, the creator. Are they actually putting it out there and saying, here's the protections and the expectation I have of the information that I'm sharing? Because what we're seeing is, and this is where I'm really curious, Joel, is in the EULAs, we're basically signing away our rights. To Mark's point about Zoom, right now, all of this stuff is being slurped into a big training model, right? And so, my style and Mark's style and your style are all being stolen right now.
I want to follow up on that because we're going to run short on time here. And you just brought in a perfect segue here. For those of you that aren't going to get the reference, there is a segment of Black Mirror that handles this. I think it's season 6, episode 1. Shannon, I had you watch it. If you haven't seen that, please go and watch Black Mirror if you get a chance. It's on Netflix. But one of the things that it reminded me of what Zoom is doing right now. They're saying, we own everything that you're doing, and we're not offering you a chance to opt out. There is no opt out on Zoom sucking in what we're doing right now. So in that case, I think that's outside the boundaries. That number one is I look at Zoom as a platform, almost a personal platform for personal conversations, and they have no right to go in and suck that in any more than somebody has a right to go in and suck in all my email, which we know Google is doing to get ads to me. But the big context here, Joel, is Zoom is saying you belong to us and you cannot opt out if you use our platform. And that's a question as much as a comment, Joel.
Okay, I was waiting for the rise of inflection at the end of that statement. You indicated such, but I wasn't so lucky. Sorry, what is the question?
The question is that Zoom is saying, if you use our platform, we own what you do.
Yes, okay.
There is no opt-out.
There is no opt-out? No, that's right. And you and I have battled this before. I've told you that as a matter of law, as a matter of contract law, we can contract away your rights. And of course, the way that we would do that there is say, we don't want to play on your platform, Zoom.
That's
Of
what
course-
Patrick just said, yeah.
Right. So, but the problem is, of course, is that it's the industry standard, right? I mean, to what extent has Zoom, at least since the pandemic, become the de facto town square? You exclude me from Zoom, and notwithstanding the existence of Teams and Cisco's, what is Cisco's? WebEx, whatever it is.
WebEx.
You know,
WebEx.
I'm essentially
And
now,
Google.
okay, so now I can't speak in the town square, but you've given me, you know, a little bit of space next to a dumpster, you know, 3 blocks away. My point is that there's nothing we can do. We don't want to give them our content, then we don't play on their platform. But, you know, everyone, as soon as you say that, everyone recognizes the impracticality of that. When Zoom controls something like 90%, at least 90% of all video conferencing, it's cornered the market, right? We're over the tipping point. There's really nowhere else for us to go and really do the things we need to do, because the other platforms are just, they don't have that kind of degree of market share.
You
So
know,
I don't like it,
yeah.
but they can certainly do it, and we can certainly surrender those rights.
Patrick, can I bring you in? Can you turn your camera on and just come in for a second? Because I know you've been part of this movement in general. When we're talking about this, is there the possibility to set up a platform that isn't monitored? And me as a promoter, let's say I'm taking it on with you and I'm saying, if you give me the platform, I'm going to blow it up. Is there something like that available? I know you were working on something for a while.
Well, there's the more of the decentralized video processing and stuff. It exists in open source and people have been using it for a while, but obviously it's the matter of crowd and convenience and price, because technically it's doable, but like who wants to do it? And yeah.
So the problem comes down to
finance. You need is a broker who does the contacting, and then you could argue like who owns the contacts and the contact graph. But on the video you could do it, right? And
yeah, I mean, it's possible for all of us to care about our rights. I think that's the issue, is like, I think what Zoom just did makes them weaken the market, because somebody is going to leverage their inability to opt out for training as a mode for being able to support their platform and better rights.
And I'm suggesting to you that on balance, it's not going to make a lick of difference, because certainly companies, certainly from a business like Zoom's business accounts, they're not going to care. They're so beholden to Zoom now and so ingrained with training their staff on how to use it that anyone directing their IT and their tools is not going to want to engage in a ramp up with respect to learning a new platform. And that includes,
well, maybe if you're recording something you don't want shared with Zoom, you're not doing it on Zoom anymore.
Maybe, and I don't doubt that there's going to be a percentage, some percentage, but it will be negligible.
No, but potentially it's still the creators that care enough, right?
Patrick?
It'll be niche oriented groups like this one that, where you're going to have some people that are invested and are going to identify another tool. But Zoom doesn't care financially about this group. It cares about its corporate accounts with Procter & Gamble.
We are saying the same thing. We are in agreement entirely. I don't know that they don't care, though, because if their trade secrets are being pumped into a model, they might actually care. So it may turn out different from my perspective when they really think about what it is that they're using Zoom for and all the idea generation.
Well, now you're really onto something, because this is one of the issues, of course, that I've talked about with you, Mark, which is that we're not just talking about AI creating fallacy. We're talking about AI now being essentially a method by which to, absorb confidential or proprietary information, which is scary stuff, not only of the entity or person who's inputting the data, but any third-party information that individual may have acquired. I've got a sales report from one of my largest vendors. I'm now going to create a question in ChatGPT that uses some of that first line revenue, right?
Yeah, our NDA is about to break. I mean, like if you're using Zoom, are you violating an NDA that you had? Those are all really interesting questions.
I'm going to interrupt here for a second because I want to make sure we're on time. Matt, I wasn't sure what our time limit was here. We're at 5 after the hour. Where are we on time? Matt Saunders or Mark Cluett or Jack?
Yeah, keep going. It's very, very interesting.
Yeah, I think we're okay for time. Just keep rolling.
All right. Patrick, if you want to jump in this conversation, you're going to have to interrupt because it doesn't stop. And I know you had some points to make there.
I wanted to say, as a product vendor using generative AI to provide services to your customer, we recently had a discussion about, so yes, we'd like to give customers the option to use the AI, yes or no, but we found that it creates like a fork in the product. Do you go, for example, for intelligent search or for non-intelligent search? And so now every time you make a decision in the product roadmap, it's going to be like, oh, we need to support both cases, like one on the opt-in. And it's not just about generating the content. It's like using AI in your product in different features. So I wanted to show that flip side of course, yes, they make a choice, but there is a big cost at us screaming about like, oh, we disable the AI. There's a cost of the company maintaining that as a product. So.
Well, and what we haven't really talked about, Mark, is that there's AI for using everybody else's stuff as inputs. But what if you're actually a content generator that wants to use AI on your own stuff? That's a totally different problem space. And you're starting to see models now where they're allowing for commingling between what's external and what's internal to create even better outcomes. And that also puts another wrinkle into the middle of this.
The other thing that is happening too, and I sent you the link last week, Shannon, is there are now open source AI engines that you can actually run on your laptop and supply your own data. From a lawyer's perspective, Joel, I think that's a fascinating thing that a company, a law firm could own an AI engine and pull in the cases that they want to reference.
Right, but that the way that you're describing it, though, that engine is only going to be as broad as that which the law firm has its fingers on. What we typically look for, at least on the litigation side, is it's precisely because we're looking for analogous cases. In other words, we're looking for factually, and ideally with the same legal outcome, what approximates our circumstances. Invariably, it's the stuff outside of the very box you just defined that we're interested in pulling.
But it doesn't have to be, meaning I've found 10 cases that relate to what I'm working on now in court. You could suck those into your engine and they are now legitimate reference points. That's what you're doing anyway. Now it's just being automated and then possibly analyzed for correlation between those 10 documents.
Well, I will tell you, again, as you know, I'm a litigator, so we use certain tools like Thomson Reuters produces the gold standard called Westlaw, which every litigator relies on to sort of look up citations. Not surprisingly, they have, because I'm also, I'm asked to sort of beta test some of their stuff, and this is public knowledge. They're incorporating AI, and the way they what does that mean? So the way that they incorporate it is, the value added they offer is if you find relevant cases and if you give us basically the complaint or some sort of first step with respect to having the engine recognize the facts of this case, it will actually draft, and someone asked this, I think it was maybe Patrick earlier on the chat, when is AI going to be able to effectively litigate a case? So it's there. I mean, it's happening. The other interesting thing is, just this past year, I believe, there was a defendant in some state court action somewhere, maybe California, not surprisingly, or maybe it was Florida, that defended themselves with an AI model. Their defense attorney was literally an AI model, which blew my mind and goes to this issue. I mean, I never looked back. I don't know how it went. I haven't seen a transcript. But that's pretty amazing to me. It also creates a little bit of job insecurity, so of course I'm interested in that. But No, I mean, it's there. It's going to happen. I tell my partners all the time, we're going to be rendered litigators are going to be rendered obsolete for all practical purposes sooner rather than later. But
I don't know about that.
But they've been saying that about baseball, right? That umpires were going to be replaced with cameras and computers for purposes of calling strikes, and yet we all see it on TV. But
umpires are anachronism to the game. You could,
you know what? That's going to happen when you can sue your first AI model. That's actually when you're going to see people become obsolete, and not until then.
Let's see here. I am saying that we've been at it for an hour now. I want to call an end to it, but I'm going to ask each of you kind of to give us a short overview on where people should start looking for the type of content that we're talking about as far as the legal aspects. Joel, I'll go to you first. If people want to follow up on the discussions that we've had, other than going to your podcast, What's in My EULA, where else should people be looking for this?
Well, a couple of different I mean, first and foremost, about 15 minutes ago, I dropped my email in the chat box. To the extent that any of you want to follow up, I'd be happy, to speak to you over the phone, or certainly you can write me an email. That's one place. In terms of other sources, there's a ton out there. I guess the problem is that we don't have a lot of guidance from our judiciary yet. So I can't, I wish I could point you in one direction that says this has a great collection on sort of the legal ramifications of AI generally. Look at this blog, look at these dozen cases. To my knowledge, and I haven't looked at this admittedly in at least 30 days, but this was something that I was interested in trying to track down. When I last looked at this about a month ago, there was nothing in existence.
Well, then that begs the question, why aren't you and I doing that as a podcast starting in September?
Well, right.
The three of us could just go crazy on this stuff.
Yeah, I mean, there's all kinds of nooks and crannies, and the only thing I will say is, to the extent that the people on here, you have clients that are in what I call the professional services. So I'm specifically thinking of like finance, accounting, and lawyers. To the extent that you're doing work for them, AI is a really scary thing, because I think if not properly utilized, meaning, what does that mean? It means if not properly independently vetted by the professional, I think they're just, at least in the United States, at least opening themselves up to just a total parade of horribles, not the least of which includes countless malpractice actions. And I'm not a malpractice attorney, but I think that is the next sort of boon within this space, is you're going to see institutional clients, individuals coming back and wanting to hold the service provider accountable for having erroneously relied on the AI platform of choice.
Shannon, your take on it. Where are you looking for this, or are you inventing your own?
No, I've been looking for it. So, law.com is one that I have in my little coffers. I've got Bloomberg. There's tons of stuff out there, actually. Those are the two that I really pay attention to. Also, interestingly, there's a variety of information out there at some of the ethical AI capabilities. So you can watch their feeds. The Bar Association, I actually talked about it. So if you go to AmericanBar.org, they actually talk about these things. I think, Patrick, you pointed to a few here, all really useful. And the reason why I care deeply, again, kind of coming back, is translating AI into tech. What can you be thinking about? What is on the horizon? How can we actually set up to put some of this information into our technical capabilities sooner? Because a lot of us, especially in DevOps, would really be would love to use these tools to be able to make and create better things and actually be more productive. So I do think it's worthy of being informed at minimum on those few sources.
Tell me something, though. I'm just curious, Shannon, the sources you just identified, Bloomberg, the ABA, law.com, they sort of report on this, though, in terms of they've not aggregated it. You're just saying.
No, I just kind of pay attention to what they're pumping out. The aggregate have actually been not that helpful. So I just added into an RSS feed, and basically anytime something pops, I get a notification for it, and that allows me to kind of aggregate too.
Yeah, well, the three of us should really talk about creating some sort of like cogent resource.
Yeah.
I don't know what that looks like, but we should at least have.
Happy to do it.
Yes. Patrick, I assume you're in on that with us? Since you had a running diatribe over there in the conversation thread. That's great. So,
it's okay. It's all going into Zoom. Eventually they'll be able to pop out. Like,
yeah, right. They're going to beat us to the punch.
All right. I am going to put a pin in it here. Matt, thank you so much for the time. Mark Cluett, thank you for the offer to come and talk and just kind of talk our way through this thing. I hope people found that helpful. It's such a broad topic, and what we want to do is I want to focus on the legal aspect. And I think the follow-up to this conversation is literally, I'm thinking about a podcast on the legal aspects of AI, because there's so much that we could cover. Anyway, thanks everybody. Matt, I'll turn it back to you for the final.
Brilliant. Thank you so much, Mark. Thank you, Shannon. Thank you, Joel. Just a bewildering amount of issues that come out of AI and the explosion that's gone on in the last 6 months to a year. And actually hearing well thought out, reasoned narrative from the likes of you is it's definitely where we need to be heading to. So yes, thank you so much, everybody. That's been a wonderful chat. Again, much with John's chat a couple of weeks ago. I don't pretend to have followed all of it. But yes, so many good links. Thank you so much, Patrick, as well for your contributions in there. And yeah, a lot to think about. So brilliant, thank you. So let's just kind of wrap up the meetup. We're going to have a little quiz. If my mouse pointer starts working again. Give me 1 moment. There we go. So let me just share my screen. This one here.
Matt, not to be rude, but I'm going to have to run. I've got another one going on. But good
Absolutely,
to see you.
no problem at all. Thank you so much, and we'll speak soon.
You.
Cheers. Okay, right. So hopefully you can see my screen. Just to make lighten the mood a little bit. Let's have a little quiz. I've cracked open a beer now, so yeah, hope you have too. So we're going to have a little quiz, much like last time. It's on Slido. I'll put the link in the in the Zoom chat. Patrick AI is going to win this. Unfortunately, it's only a quiz that I can send. I'll send you one of these books. The winner of the quiz, if you're in the UK. I might make an exception if someone called Patrick AI wins it, however. But he knows everything in all these books anyway. So the 3 books. Number 1, you get a choice of one of these 3 books. Hacking Kubernetes by Andrew Martin and Michael Hausenblas. Number 2, Security as Code by BK Sakat-Das and Virginia Chu. And number 3, DevOps Tools for Java Developers by 1, 2, 3, 4 people whose names I'm not going to read out because we don't have time for that. So please do join the quiz. DevOps Dover, I'm not sure you're allowed to win because you're part of the organising committee. What have I told you about this sort of thing? Okay, so right, here's a quiz. The questions are really hard, so I hope you've been paying attention. So yeah, good luck to everyone. Let's get going. Right, so first question. Mark Miller runs an annual virtual conference on DevOps. What is it called? Is it all year DevOps? Is it all month DevOps? Is it all day DevOps? Or is it all hour DevOps? Vote now, quick, you've got 3 seconds left. All right, well done to most people who have got that right. Well done. All day DevOps is the answer. And who's will it? Oh, Dover, we're going to have a word about this. Okay, congratulations to Not AI, who is our leading, I was going to say our leading human participant, but then that suggests that Dover isn't human, which he probably is. There we go. Yeah, so well done to Not AI. Right, second question. Shannon is one of the founders of which community website? Is it devbizops.org? Is it devsecops.org? Is it dev test build monitor noops.org? Or is it destroyallmonsters.com? Adding bits into DevOps got a bit silly at the end, so I don't know where that came from. My own imagination. Okay, so well done to most people who've got that right again. devsecops.org is correct. Who's winning now? David, if it's you again, I'm just going to delete you from the organising committee. Not AI has come to the fore. I suspect a tactical withdrawal from Mr. Dover. Congratulations to Not AI, and Patrick AI is second, hot on the heels. Third question. Name a popular generative AI image tool. Midjourney, Endgame, Start Flight, or Into Image. To be honest, I didn't actually check the 3 wrong answers here to make sure that they're not actually Gen AI tools. But I'm sure you know what the right answer is anyway. And it is Midjourney. Oh, a few people said Endgame. Interesting, interesting. Is it at the top now? Yep, Not AI still there. I can't see those times because my Zoom window is in the way. Oh, you're 3 seconds ahead, Patrick AI. So it looks like the humans are beating the actual AI at the moment. So I think that's a good thing, right? Question 4. London DevOps has been running since 2014, but how many meetups have we run to date? Is it 7? Is it 6? Is it 67 or 76? 5 seconds left. Get your answers in. And boom. It is 76. And I don't think anyone's been to every single one of them, but there's a few people we see a lot, which is great. Well done, 86% if you got that right.
So, ladies and gentlemen, forgive me, pardon the interruption, but I have to go as well. But I just wanted to, again, thank you for the opportunity to speak to your group. And again, I just threw my email there in the chat box. If anyone wants to get in touch with me, I'd be happy to do so. But I wish you a very pleasant August and the rest of your summer, folks. Hopefully we can do this again. Thanks.
Brilliant contribution. Thank you so much, Joel. Enjoy the rest of your afternoon. Cheers. Okay. Not AI forging ahead. Oh, and yeah, Patrick AI has descended the leaderboard there because I think you might have got that one wrong. We forgive you. We forgive you. You're not in London. Number 5. Which of these is a quote from the lawyer who Joel was talking about, Steven Schwartz? Was it, "I did not comprehend that ChatGPT could fabricate cases"? Or was it the same thing? Lawyers, witnesses, or cake? I wish I had an AI to bring me cake. That would be a win. Okay.
That would be awesome.
Cases is the answer there. Although I still haven't had my my apricot yogurt from Jack's house yet, so maybe I'll just skip straight to the cake. So there we go. Congratulations to Not AI, whoever you are. Can you please message me either on meetup.com or via LinkedIn? I'm sure you can find me if we're not already connected, with your, well, first of all, actually, Mr. Not AI, or sorry, or Miss Not AI, or whatever gender you are, if you're there, are you able to come off mute and just say if you're in the UK or not?
Hey, sorry, I'm not in the program in Netherlands.
Did anyone hear that? Because I didn't.
No?
That's better now. Can you repeat that?
Yeah,
repeat.
sorry, no, I'm not in UK. I'm in Netherlands.
Not in the UK, in the Netherlands. Oh, never mind. Well, congratulations. Well done for winning the quiz. Unfortunately, I can't send the book to the Netherlands. So let's move on to Krish. Are you there? Are you in the UK?
Yeah, hi, I'm in the UK.
You're in the UK. Excellent, excellent. So yes, if you can find me on meetup.com or LinkedIn, and send me your address, and I'll remind you of which books, when we get in contact, I'll remind you of the book choices we have, so you can choose one of the 3 O'Reilly books for the giveaway. Well done also to Fuad and Andreas. Is that you, Mr. Heisenberg? I remember you. Long time no see. It is excellent. Excellent. Hope to see you soon, man. Good to see you. Cool. Okay, so that's that. We're all over for London DevOps for tonight. Just remains for me to do a little bit of admin. Number one, our next meetup is featuring Patrick, who has performed such a brilliant contributory role in both of the virtual meetups so far. We thank you so much for that. Hopes are now high for your talk, which is going ahead on September the 5th. That's going to be, so about 4 weeks, probably 4 weeks today, something like that, after everyone's been on holiday. So yeah, really looking forward to that. Thank you very much to Mark, to Shannon, and to Joel for a brilliant talk. As I said, when somebody comes to you and says, yeah, we're not going to have slides, and you're like, ooh, hang on, what's this going to turn out like? And yeah, I thought it was really, really awesome, and I hope you did too. Please send us feedback on how you thought it went, if you enjoyed it, if you didn't enjoy it, anything you want us to change, etc. Massive thanks to our sponsors. I see Ari's just come onto video there. So yeah, thank you again to JFrog and to all of our other sponsors. And yeah, I think that's about it. Enjoy August, everybody. Hope you've enjoyed this meetup. We'll see you soon. And thank you for coming. Cheers, everyone.
Thank you,
Good night.
Thank you, everyone.
Thanks, Matt. Yeah.
Can't actually end it, just have to wait for everyone to drop off, which is fine. Bye-bye.